Hi there, you're with PQ Prime, and this is the fine print. Market regulator SEBI wants to change the rules of the game for insider trading and suspicious trade in the securities market. Via separate consultation papers, SEBI has made two broad suggestions. One, that all material information that companies are required to disclose under listing regulations be treated as price sensitive for insider trading purposes. And two, a new framework for unexplained suspicious trades be introduced where the burden of proof lies on the accused. To understand what's prompted SEBI's suggestions and how they are likely to impact the enforcement in the market, I'm joined by Shruti Rajan of Trilegal and Sumit Agrawal of Reg Street Law Advisors. Shruti, Sumit, welcome to the fine print. Shruti, let me start with the consultation paper that talks about treating all material information as unpublished price-sensitive information or UPSI for insider trading purposes. Now, what SEBI is saying is that currently information like, sales or production data or potential investments, strategic tie-ups, brand acquisitions, they're sort of disclosed under listing regulations, but they're not necessarily treated as UPSI by companies. And when trades happen based on this information, insiders come back and tell SEBI that, look, this was not treated as UPSI by the company. How are you expecting us to treat this as UPSI? So uh, to sort of bring over this hurdle or to get over this hurdle, SEBI is now saying that we're going to treat everything material under LODR as UPSI. What do you believe is the reality of the market that requires SEBI to do this?
So, Baswini, at the outset, I think, most of us who've seen the law evolve through the years would have been quite surprised to see us all go back to square one on this, right? Because I think after the TK Vishwanathan committee report, this was something that we assumed was settled because the committee actually deliberated and examined the fact that there is a difference sometimes between what the company considers material enough to disclose and inform its shareholders about under Reg 30 versus issues that could be price sensitive. There is sometimes an overlap, and the committee acknowledged that. But there are instances where one does not automatically lead to the assumption of the other, right? So a disclosure does not automatically lead to the assumption of it being UPSI. So I was a bit surprised, honestly, when I saw this. Because to me, the paper as it stands today also does not go into too many details as to why this reversal was required, right? Because even the 92 regulations, etc., did not have the assumption of, material disclosures actually becoming a part of UPSI. To my mind, whether the fact that this is a defense people have been picking up is good enough reason to amend the regulations, I don't think so, because the way you would see insider trading defense operate is it's one of the many defenses, right, that people would pick up on. And at the end of the day, I would think that an amendment like this, and as and when SEBI brings it in, is going to require a far more of a legal basis in that sense to demonstrate the to the regulations. And secondly, from a compliance officer perspective, I think this puts them in quite a spot because, for them, what this is doing is really amending the definition to say that now treat all of these as UPSI, which means there's trading window closure, there's, how you're going to look at pre-clearances. So a parallel clarification on that as well is something that SEBI should certainly consider bringing out here.
Okay, so I'm guessing closer to when they decide to implement this, those clarifications will come in. Sumit, coming here, there is at least one data point that SEBI has mentioned in this consultation paper to say that between Jan 2021 and September 2022, we looked at 1,000 plus press releases, out of which the information on that press releases impacted the stock prices of over 227 companies by over 2%, but only 18 categorized that information as UPSI, while over 200 didn't. Is it, I know it's a sample case that SEBI is, using to support its, proposal, but do you believe that increasingly it's getting difficult for the regulator to enforce against insider trading, and hence they are saying, look, we're going to consider everything UPSI. So, go figure.
Vaishali, that's an interesting question. I think the data analysis which has been done by SEBI points to a serious problem. And this is not some individual problem with some kind of a nifty 50 companies or the top 100 or top 500 companies. They have done an industry-wide analysis as put in the consultation paper. But if one has to read this current consultation paper in isolation, then I think it will seem to be draconian. But if we were to link it with the earlier consultation paper, which had come in the December month last year, where SEBI had proposed to bring some sort of a numeric threshold to the materiality under the listing regulations. They proposed that there is going to be 2% turnover or 2% of the net worth or 5% of 3-year average profit or loss after tax. If these criteria are looked in a combination, then certain information is going to be considered to be material. So what SEBI is doing is SEBI is taking two-pronged approach. One, they are changing the concept of a material information per se in the listing regulations, and the material information, once it is based on numeric threshold, is being included in the insider trading regulations. So if both the amendments are to be looked at together, then perhaps we could come to some sort of a logic to it. However, while I empathize with the problem of a regulation, my reservation is that it blurs the line between UPSI and MNPI. And what it does is that there are both sides of judgment from Securities Appellate Tribunal, one set of judgments which distinguish between what is a material event or an information, and it necessarily need not be UPSI. Equally, in certain facts and circumstances, Securities Appellate Tribunal has said it doesn't matter whether it is UPSI or not, as long as company has believed it to be material information, it is disclosed, mere knowledge of it will make it UPSI. So what industry seems to have done, which SEBI seems to have a problem with, is that these particular some of the exceptions in the judgments have been utilized by them to avoid disclosures. To deal with this subpar disclosure problem, they have proposed this amendment. However, the fundamental question remains that for a listed company today, why does one need to have two differentiating concepts? And earlier, as Shruti said, and I agree with it, that from 1992 till 2014, it was not there. In 2015, it was introduced. It remained on paper till 2019. In 2019, it was removed. We are back in 2023, back to square one. Consistent changes. I think whether it is a solution or it is actually the cause of the problem.
Shruti, so there are a couple of points that Sumit has raised, right? That look, judicial proceedings have muddied the water for SEBI enforcement. So they're saying, look, we don't even want to go to the courts now to determine whether something was material and should have qualified as UPSI, because it's under discretion of the company, and then SEBI finds it difficult to argue against those facts. So now they are saying, look, we are finding it difficult to enforce. We keep running into the wall where precedents are cited to say that, look, this was not UPSI. So what is the downside that you see? Or let's say if you could go back to the era where this distinction was never existed, the problems that companies had to face, the regulator had to face, do you think those might come back, and what could be some of those hindrances?
No, absolutely. So in fact, when Sumit mentioned the amendments, I think another proposed amendment we should bear in mind is in, I think, end March or Feb, if I'm not mistaken, SEBI has also suggested that where there are market rumors, right? Today, as a listed company, I need to go out and make disclosures in relation to that as well. So take a simple thing as an example, right? Let's say that there is a market rumor about a company having received some kind of an income tax notice or some kind of or an investigation being underway. Let's not even go as far as a notice. Now, today, a lot of companies, there are a variety of investigations everybody faces. Initiation of not every investigation is necessarily disclosed at the stage at which the investigation or the information gathering commences, right? Now, the moment something like that becomes disclosable under the LODR, let's say there is a rumor in the market that there is a particular, let's say there's a FDA investigation or some kind of a regulatory investigation starting on a company. It's at a very initial stage, but it gets disclosed. The moment the company has to then pick up that market rumor and clarify, saying we're confirming or denying that. What does the compliance officer do with that piece of information for the lifetime of that investigation? Does he continue to treat that as UPSI, because investigations in this country continue for years? Every step of the investigation perhaps has a new angle to it, and could potentially be considered as impacting the investor's approach at every stage, right? As and when the situation develops. So what is the role that a compliance officer is expected to play here? And I know I keep harping on it, but that in fact answers the question that you asked me as to what was the problem that we were seeing earlier, right? And I think this whole issue of the individual's liability, of how the company is supposed to take this concept, implemented into their systems, look at trading window, look at compliance. There will be senior officers in the company going to the compliance officer and saying, how long am I not supposed to trade? Till when is the window shut for me? So when you look at things like market rumors and all of the other amendments that have come into place, and like Sumit said, I agree that obviously this, as well as the other consultation paper, are driven by a need that SEBI sees. But I think that when we introduce it, there will have to be a balance in terms of understanding, what is the other side of a disclosure like this? What does it really entail? And that's one part of it. And secondly, I think when the TK Vishwanathan committee discussed this, one of the aspects to their mind was to make sure that disclosures are not, in that sense, mindless, right? The company is applying its mind to the kind of information that it wants its shareholders to know. Today, if we feel that listed companies are not doing that, there is a different way to deal with it. Amending the insider trading regulations to introduce that is not the solution. So I think the problem that they've identified is certainly something that everybody would sympathize with, but the solutions are not just this amendment. I think there are various ways to solve and come to a better solution.
The companies are not disclosing UPSI to the satisfaction of the regulator. Is it that, and the example that you gave, that there is an outside investigation by a regulator, would it help if you say that, okay, material information emanating from the company?
It would. And I think if they were to bring out certain thresholds, right, you could make that, you could actually go with, say, a 2% or 5%, something which says that, look, is this going to have a financial impact on the company, which is significant? Is this going to have an impact on your ability to continue business? So I think those kind of, pointers are perhaps going to give the market a little more guidance on how to go about this.
Sumit, you want to add to what other caveats? Because it's like I mentioned, it's still at consultation stage. So I'm guessing all of you on the behalf of the clients you represent will make certain representations. Any other caveats that the regulator can add to make this problem solvable? I don't think either of you are denying that this problem exists, but equally not make compliance, burdensome for companies and their officers.
See, I think enforcement of any regulation or any law is obviously going to face various challenges. But for every problem, bringing an amendment is not the solution, and it may not be even sufficient. And I seriously think that in this case, one needs to go to drawing board back and see whether we want to use this material non-public information, unpublished price sensitive information, material information, or a material event. These are the four terms which have completely blurred the distinction, and the companies are also not clear, even despite having the right intent to disclose, when to disclose, what to disclose, how much to disclose, and the consequences are of course severe. So I think that somewhere revisiting Reg 30, which under the listing regulations require the disclosure, and connecting it to the UPSI definition needs to be completely clubbed in one regulation for the listed companies. Definitely there has to be.
But we're talking now of third sort of framework, but if it's just got to do with the definition, isn't it just easier to fix it in LODR and then say that, look, this applies for UPSI purposes as well?
See, then otherwise, perhaps alternate could be that in the context of UPSI, you only define on a principal basis and do not provide an indication per se. Today, you have 5 items in the UPSI definition. You are trying to add the 6th item, material events, under listing regulations. Tomorrow, for clarification, you would want to include a 6th item, 7th item, 8th item. There is no end to that list. And another problem is going to be the moment sometimes the clarifications come from the regulator, they come in the nature of a clarificatory amendment. And it is often argued that they are retrospective in effect. That further encourages.
Okay. No, let me keep this focus. What would you, in the context of what SEBI has now suggested, you would like to see? Would you then say that look at UPSI completely different from how you're looking at it? Because I'm guessing this will be just one of the additions, like you mentioned, to the definition of UPSI.
I think it should only and only be principle based without any indications. And let those
principle
principles
is
govern.
not working, Sumit. That's what SEBI's problem is, that the principle-based regulation is not working. They keep running into this hurdle of trying to sort of prove it to courts that, look, this was unpublished price-sensitive information that should have been qualified, and trades shouldn't have been made on the basis of it. So clearly there is a gap between the regulations and SEBI's ability to enforce, bring enforcement action.
Agreed. And my counter to that only is that if you are going to make 10,000 regulations, you are destroying all respect for the law.
Yeah.
It's not going to
But
solve the problem.
Sorry, Sumit, if I can come in there and maybe you'll agree to that. This threshold and materiality idea, it'll actually help SEBI and it helps the market. I'll tell you why. And Sumit will of course, resonate with this. In a lot of our matters which involve disclosure of, say, M&E, right? One of the bigger issues that come up and obviously Abhijit Rajan was entirely about that, is today when I am trading and there is a transaction as well, which is underway, but the transaction itself is not material in terms of its size to the, the larger business of the company or the net worth of the company. Today, that aspect, right, has also been used by companies to not make disclosures. So let's say today I'm a 9,000 crore, net worth company, and I'm acquiring like a little shop, like a back office kind of an entity for a couple of crores. Okay, and in fact, that is a situation that we had seen in the past. I don't make a disclosure. It is in my right to assess as a company whether that information is material or not. Now, given that the law does not have a metric to it, SEBI continues to insist that no matter how insignificant the acquisition, you should have made a disclosure under LODR as well. But that percentage or having some kind of a ballpark threshold serves SEBI's purpose because people who meet that will disclose. Two, it serves the compliance officer's purpose because he actually has some numerical threshold to refer to when he decides on whether a disclosure is made or not. And three, it affects how an investor would look at that as a defense tomorrow if it's looked at as UPSI. So that is something SEBI can certainly consider.
So the thresholds that they have now, they've now revised of materiality, that should be helpful then, right? In the example that you gave.
Absolutely.
Definitely.
Okay. Let me so both of you seem to think that this is going to be broad-based. It will take us back to a time where compliance officers are confused about how much to disclose and whether there will be any sort of trading windows in the life of the company for people to trade. So one option is that you make it principle-based, as Sumit said, but I think SEBI is saying it's not working. And the other option is for SEBI to look at maybe materiality thresholds more closely and say that only information that's emanating from inside the company will be sort of looked at as UPSI for insider trading purposes. Let's move on to the second consultation paper and second proposal, and I'd like to get your thoughts on that. And this has got to do with suspicious trading activity in the market. And SEBI is saying that there is this suspicious trading activity in the market, but it's not always possible to go after these entities because they're carried through sophisticated technology, or it's not always possible to show that the unpublished price-sensitive information was communicated. And even if you go as far to be able to make a case on that, it's difficult to show that the relation between suspected entities is up to the legal standards that has been set for the regulator. So SEBI is saying we need a new framework for such situations. Shruti, first I'll come to you. You'll acknowledge that this problem exists.
No, of course. See, I think we do know that there is a universe which does not fit into PIT and does not fit into FUTP. And in that sense, it was perhaps in SEBI's eyes falling through the cracks, right? Now, the form in which something like this should have come should have just been an amendment to the FUTP regulations. Do we really need a separate piece of law? Going back to Sumit's point on how many, regulations that can you possibly have in the market? I think all of that is one part of it. But yes, today, have we seen situations where, SEBI has tried to investigate all of this, but not been able to find that one clincher either under PIT or under FUTP? I suppose, yes, the answer is true. And that's not, SEBI is not alone in that journey, right, Paswini? Today, the way technology is impacting investigations world over, it's a reality that technology is, as much as it helps because of surveillance tools, technology equally hinders because you have all these ephemeral messaging apps and all of that. It's making it tougher for regulators world over. So yes, I understand the need for them to think in this direction. The end result is something, of course, that we will speak about through this.
Yeah. So I'm sort of less concerned about whether it has come in as, let's say, 3 separate regs within FUTP or, via a separate framework, Sumit. But what I'm trying to sort of get to is that there is a difference in approach here in terms of how SEBI will prove these cases. They're saying here that the burden of proof will lie on the accused to rebut that their trading activity shouldn't be considered suspicious, and that it was not made around when material non-published information existed. Um, what do you make of this approach? Because unlike the new proposals, the existing framework of FUTP and insider trading put that proof burden on the regulator and not on the accused.
I think, given my experience of surveillance in SEBI, I think this entire, both of these concept papers are trying to find a solution to 2 Supreme Court judgments, which is Balram Garg and Abhijit Rajan, as well as perhaps
You want to first elaborate also for the benefit of our audiences that what these 2 judgments broadly held, so that people have context.
Sure. So Balram Garg was the judgment where Supreme Court held that SEBI needs to have stronger circumstantial evidence to prove insider trading and not rely upon patterns alone. While in Abhijit Rajan, Supreme Court held that insiders' motive to make profit is an essential ingredient to establish the charge. And these 2 judgments have raised the threshold of proof required and the evidence which needs to be collected by SEBI's surveillance and investigation. This problem, coupled with possible denial of the government in non-granting powers to encrypt and decrypt electronic communications to SEBI. Now, SEBI has these limitations, and SEBI needs to, of course, take its job very seriously. Possible solution, SEBI has come out with this regulation in the form of a new law. However, the problem lies in that SEBI in the concept paper itself has compared this kind of a new approach with something like unexplained cash credit and income tax.
Yeah.
Those provisions are in the parent statutes, like Income Tax Act itself has Section 68, or US in the context of private securities law claims has in Securities Act 33. No such provisions exist in SEBI Act itself. And if you were to come up with an approach of this kind of a law where on the basis of suspicion, you could pass a direction, then imagine if ex parte ad interim kind of an order could come, which SEBI has the wide powers of, that will really be draconian. So therefore, if this law were to come, SEBI will have to also come up itself with some sort of safeguards to make this test of law being constitutional. Otherwise, it is going to face challenges.
Okay, the way to do that is then, like you mentioned, is to amend the act itself and not bring this by way of regulation. Shruti, you put it very interestingly in our offline conversation that you see this as the baby of FUTP and insider trading regs. What do you believe would be the consequences of saying that we think this is suspicious trading activity. And now and they've listed some measures that, or rather some arguments that the accused can take to make their case. Is that not enough to your mind?
So I think a couple of points there, Vaishwani. Look, the regulations, and it's important for us to know that distinction at the outset, that the standard of proof that they're looking to introduce in that sense will be applicable only to the universe of trades that fall into these regulations, right? This can't overcome the the pronouncements which are there insofar as Balram Garg, Abhijit Rajan are concerned, which is very specific to insider trading, and that is the law today, right? And that is what today as SEBI and as the tribunal, and of course the Supreme Court itself, will look at as law of the land insofar as PIT burden of proof is concerned. I think SEBI's fear perhaps was that those concepts should not get imported into another universe which they are trying to regulate, which is of suspicious trading. And if you look at that, I think those defenses will need far, far more work. Because where do I start, right? So for instance, if you look at, say, terms like abnormal risk, abnormal reward, that is the nature of the market. There are traders who are working for years to achieve exactly that. So you have multiple, you have like quant traders, all of them work with certain, ideas in mind. So how is SEBI going to define the abnormal trade, abnormal risk reward? That is, I think, the first point insofar as the definition is concerned. In the defense, I would think that SEBI will have to introduce a few more parameters. So for instance, let's say I'm a quant trader. Okay, again, I'm going back to that example because it's a real one. On a daily basis, my goal is to achieve abnormal profit. I may not be able to show you a repetitive pattern because I go with what my AI guides my systems, to trade. So I think SEBI will have to make certain exemptions for maybe certain kind of businesses, right? Today, if I'm an organization and I'm able to show you that, look, I am a licensed entity, otherwise you've not had a problem with me through my inspections, just by looking at my trade pattern, right? Unless you as SEBI are able to discharge a slightly higher burden of proof in relation to my access to information, I can't automatically be held liable here. That's, I think, the first piece. Second is, again, here there is a difference between material information and going back to that whole price-sensitive information universe. So here also, for defenses to be workable, viable, the standard of what is price-sensitive information has to be the same. They can't be using the term MNPI or material non-public information here. You can't be saying UPSI for the purposes of everything else, because ultimately it's an objective standard. And information is perceived by a reasonable party to affect the price or not. And that cuts across all regulations. So I think those two items from a defense perspective are what comes immediately to my mind. But yes, some more objectivity across all of the defenses is very important.
Yeah, so if I can call out some, Sumit, I'll just come to you. I'll call out some of the defenses for the benefit of our audience, since we've mentioned it a couple of times. What SEBI is saying is that, look, if we come to you and say that, look, you've made these suspicious trades, and on the basis of that, we pass certain directions, you as the accused can take certain defenses, but it's the accused that has to prove that the trades were not based on information that was material, trade was not based on information that was, not publicly available, or that the trade pattern was not repetitive and it doesn't exhibit substantial change in risk taken, etc., to which, Shruti is suggesting a couple of additions. Sumit, I'll come to you now to add to make your point.
In fact, I would want you to read the definition of MNPI. And interestingly, you will find that the definition of MNPI, material non-public information, unlike in unpublished price-sensitive information, uses the term it has a reasonable impact and not the material impact.
Yeah. So it means, and I'll read it out, shall mean and include information about a company or security which was generally not available and upon becoming generally available had reasonable impact on the price of the securities of the company, or information about an impending order in a security which when executed reasonably impacted the price of that security, or information about an impending recommendation, advice by name, etc., in a security by an influencer to the public, followers, subscribers, etc. And when it became generally available to public and subscribers, reasonably impacted the price of that security?
Now, here you have material non-public information defined as not having material impact, but a reasonable impact. In the PIT regulations, unpublished price sensitive information has the material impact. So therefore, I think both the concepts need to be in sync. And I agree with Shruti that you can't have two varying standards for the information to be disclosed or even the trading activity to be prohibited on it. I have another point that perhaps the definition of influencer also needs to be looked at, because the way today currently it is worded, all of the people who are discussing on this channel right now and the finance minister and the SEBI chairperson would also be included in the definition.
Yeah, well, those are not the people who are making advice, but I take your point that maybe there could be a subscriber threshold. But Shruti, we have seen, and I'm not going to take the names of cases because both of you will get jittery in then commenting on them. But recently there was a case, right, where SEBI has, cracked down on YouTube channels where, stock recommendations were made, and prior to that, people took positions, etc. And there could be friends and families of these influencers, taking positions. And maybe it's those kind of entities now SEBI is saying we also want to catch, because they directly don't fall under either FUTP or insider trading. And the burden that SEBI now wants to sort of, discharge, it wants to lighten itself and put that on the accused.
Yeah, no, absolutely. See, I think if the game is getting tough to play, changing the rules of the game doesn't help anybody. Right. And I think that's something that we need to bear in mind when we look at burden of proof. Everybody is sympathetic to why SEBI needs to look at this and figure out a solution. But the way they flip the burden of proof, and Paiswini, I must tell you this, even under the Evidence Act, being able to adduce a positive fact to prove the negative is the toughest thing to do. And most of us who are, insider trading defense lawyers in that sense, that is the hardest thing to do. How do I prove that I did not do something? Right?
How do you prove a negative? Yeah.
You cannot, yeah. So I think, and courts honestly over the years have been sympathetic to that, because they do say that, look, I have a standard of proof to meet in every proceedings, right, up to a certain level. But I can discharge that standard not to a certain level if I have to prove the negative. So today, if I have to prove that I did not do something, courts have to be sympathetic to the fact that there is only so much I can bring to the table to discharge my burden. That factor, I think, is critical for them to keep in mind when they are populating this defense. Because the impact of it is otherwise draconian. And like Sumit said that, how will it stand the basis of a person's constitutional rights tomorrow if it were to be exercised on an ex parte basis?
Okay, all right. I'll leave it at that. We're completely out of time. So on the second proposal, like both of you mentioned, the defenses need, a relook in the consultation paper. SEBI needs to be more specific in how it's defining, MNPI. To Shruti's point, why use this new term MNPI? Why don't you just keep it as UPSI, which people understand, which we have precedent over? And finally, the constitutionality of it will, of course, be tested in the course of time. Shruti, Sumit, many thanks for joining us here on The Fine Print, and thank you so much for watching.